Hear ye, hear ye. The Honorable Chief Justice and Justice of the Supreme Court of the State of Michigan. All persons who have business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Well, good morning. This is our second day of our April call. As always, there'll be 30 minutes per side for full grants and 15 minutes per side for arguments on application. Furthermore, there's a 5-minute free fire zone for full grants, which of course may be waived, and a 2-minute free fire zone in arguments on application, which period may also be waived. Appellant, at his or her discretion, may reserve a reasonable amount of time for reply, but it is your obligation to request such time and to keep track of the clock. Finally, I believe it would be most helpful to the court if first you recognize that the judges are reasonably conversant with the facts in your cases, and second, that we are committed not only to resolving your case justly under the law, but also countless numbers of cases in the years ahead that may deal with similar or related issues. I'd like to also make clear that because of Justice Young's imminent retirement from the court, he will not be participating in today's arguments for the simple reason that he won't be able to participate in the resolution of those cases. But when his successor is selected, he or she will have available to them the transcripts and videos of these arguments, and that individual will then exercise his or her judgment concerning whether to participate in these cases. I understand we also have a very distinguished jurist from Japan in our audience today. Is that correct? Mr. Toshihiko Fuji, thank you very much. We're very honored by you being here, and we hope you find it instructive and informative what we're embarking upon this morning. Thank you. Our first case is Bettina Winkler versus Marist Fathers of Detroit. Please proceed.
Good morning, Justices. I'm Nicholas Rumel. I represent the petitioner, Bettina Winkler, and as I stand before the bench and prepared for oral argument, I'd like to take a slightly different approach than I did in my brief. As I read these cases in preparing, it emerged to me that there are really two parallel doctrines, one that has evolved in the federal courts and through the Supreme Court, and another that has evolved in parallel way and in many overlapping ways, but a little bit differently in the state of Michigan. And what I'd like to do today is talk about those two evolving doctrines, talk about the exceptions that have arisen, one of them that we call the ecclesiastical abstention exception, talk about the approaches that the courts take, and in the court's order you talked about jurisdictional versus other approaches. And we're also going to discuss why the DeLaycon case cannot stand, not only because it doesn't follow either of those parallel paths set out by either the U.S. Supreme Court or the Michigan Supreme Court. But it cannot stand even based upon the positions of both parties today, and because it stretches the doctrines too far, and while it could probably be distinguished, the better course would be to overrule that case and to grant leave and to have an opportunity to clarify the contours of the ecclesiastical abstention doctrine. When we get to, first, federally, we talk about that Watson case, the U.S. Supreme Court case in 1871, and they talked very strictly about questions of discipline, faith, or ecclesiastical rule, custom, or law decided by the highest of the church judiciatories.
Counsel, good morning. I just want to ask you a question. I know we're going to get into the procedural issues of this case, which is the cornerstone of it, but I just was wondering if you could answer me this. What does your client want?
My client wants an opportunity to try her case, Justice Bernstein. This is, and I'll jump ahead a little bit because, you know, we drafted this as a purely statutory discrimination complaint.
But what does your client want? To try her case and to achieve what?
A finding that the school violated the Persons with Disabilities Civil Rights Act.
And just another question. Why was this not brought in? Does this school in question receive federal funding?
They do not accept federal funds as far as I know, although we did not get to that point because there was no discovery.
I understand.
And that actually can lead me to one of the things that I want to emphasize about this case. This is not a civil tort case like so many of these other cases that were cited by our briefs. This is a purely discriminatory statutory case that cites the PWDCRA that, as the court knows, you apply this, you look at a discrimination case by, do you make a prima facie case? And in this case, not only by indirect evidence, but we believe plenty of direct evidence where the defendant was very upfront by saying we don't want to accept a learning disabled student. And then the burden would shift to them to articulate a non-discriminatory reason for the non-admission, and then we would have an opportunity to show pretext. It's the kind of case that can be decided without straying into those decisions of ecclesiastical religious doctrine or ecclesiastical polity. And when you look at that exception to the ecclesiastical abstention doctrine, it's really the flip side of the neutral principles of law. On one hand, the courts are saying neutral principles of law, if you can decide a case by just looking at the pleadings or without getting into purely ecclesiastical matters, those are really two sides of the same coin.
Counsel, Marist Fathers says that they strive to create an atmosphere in which the student's faith can grow, and they attempt to provide means and opportunities for participation in faith experiences. Now tell me, why is it not part of what defines the atmosphere that they're referring to, the nature of the student body that attends that educational institution? Why isn't that a fairly broadly based concept that's certainly broadly based enough to encompass the type of student body that's created at this educational institution?
Thank you, Justice Markman. There's no question that there's a religious aspect to their service. In this, one of the things I wanted to talk about today was how sometimes as doctrines evolve, there's a little bit of, a court will cite a prior case, but maybe rephrase it differently, and then the contours of the holding, even though they're citing the same case, the contours of the holding change. It's a little bit like that child's game of telephone, where, you start off by one person says something, goes down the line, and it changes a little bit. What the case has started out, and this will give me a chance to talk about how the U.S. Supreme Court talked about hierarchical decisions made by the highest body of a church can't be disturbed. In Michigan, we talked about purely ecclesiastical decisions. In fact, the Benison case even uses that in italics. The Michigan Supreme Court has repeatedly recognized the rule that judicial interference in the purely ecclesiastical affairs of religious organization is improper. And they cite Berry versus Bruce. That purely word kind of got left out of the DeLaken holding. DeLaken said, really without any sort of backing, that we can't, if you're going to stray in any way, shape, or form into questions of ecclesiastical questions, we can't even inquire into that. Well, I've already demonstrated how our pleading doesn't make any reference to ecclesiastical.
But no public school could have established a similar mission to what Marist fathers described as their mission in that statement, could they have? No public institution could have said, we wish to create an atmosphere in our institution in which the student's faith can grow and prosper, right? Okay, so there's obviously something that goes into the definition of that mission that seems to derive to some extent and in some way from the religious nature of the Father's mission in this regard. Is that not true?
That is true.
Is it fair then to say that this is actually an indirect statement of an ecclesiastical commitment?
I would agree that there is an element of ecclesiastical commitment. Anything that a church does would have that element. One of the other reasons why this case and the like are different is because we're not talking about things for the members of the church. The Roman Catholic Church is hierarchical. We recognize that in Gonzales in the Supreme Court, Massachusetts and Michigan. And everything that these other cases talk about are for the members of the church. Well, non-Catholics can go to this school. This is services to a third party. The questions arise, can they put something on their website that says, if you are disabled, do not apply to our school, we won't accept you. If you are black,
well, I
same
understand
thing.
that non-Catholics can go to this institution, but don't they have to accept and acquiesce in the idea that if they do attend that institution, they'll be receiving an essentially Catholic education?
They will be receiving, I did not go to Catholic school. I understand that, they have those emblemata, that they have the religious class, that there is that element to their education. But this case can be decided without reference to those issues. This case can be decided the way we decide any other discrimination case.
Can I stop you there, Mr. Ramel? So I understand that your view is your pleadings, your pleadings did not dip your toe into ecclesiastical doctrine, but their defenses have, at least, right? So what work do you think the ecclesiastical doctrine should do here? The abstention doctrine, is it if it's not subject matter jurisdiction, is it an affirmative defense? Where do you think it fits in? Where does it fit in doctrinally?
Justice McCormack, I do agree that this is an affirmative defense, and both parties here agree this is not a C4 or jurisdictional issue. The courts consistently make factual findings about, they look at the facts about how the decisions were made by the courts when we're talking about a hierarchical decision, or was a decision made by your highest body. And they also look at necessarily, it's almost like the courts say, we can explore the contours of these facts until we run into purely ecclesiastical matters, then we must turn back.
So if you agree it's an affirmative defense, and the school's mission is, as Chief Justice Markman described it, why isn't it then, why don't those qualities of its mission make their decision about who does or doesn't receive an education a matter of ecclesiastical governance? Why isn't that kind of the end of the story?
That is...
If you concede that it's an affirmative defense, I mean,
It would be the end of the story if it did run afoul of the ecclesiastical abstention doctrine. I believe that the court would have to make findings of fact. I believe that that defense, the ecclesiastical defense, is an affirmative defense that after fact-finding would be raised in a C-10 motion. Now, you might see in the pleadings that, okay, obviously, you're like in Lycon, they believed that on the pleadings that there were too many issues of ecclesiastical issues raised by the pleadings. You could probably make a decision on the pleadings in some cases. In other cases, I believe that discovery might determine that. And there's really a third exception that we don't talk about too much. All of these courts talk about, well, if you can make a decision with just reference to civil law, that's okay. That's not running afoul of the ecclesiastical abstention doctrine.
Why is this an affirmative defense? I thought that an affirmative defense was something that was generally waivable by the parties. Nobody would think that in this case you and the other side could get together and say, well, we have no trouble in this case if the courts entangle themselves in theological doctrines, and we'll allow the courts to do that. You couldn't do that even if you both waived it, could you? Does that properly describe an affirmative defense?
I believe that, I would agree that is true if it's a jurisdictional defense. I do believe that under the law that affirmative defenses can be waived if they're not properly
Well,
raised.
like you said, that's the whole premise of my
Yes.
question. They can be waived, but certainly the proposition can't be waived that because both of you agree to it, the court should be allowed to entangle themselves in the question of deciding what the faith of the Catholic Church is or any other church, right?
That's an interesting question. There's a circuit court case out of Muskegon called Wink, where the court found that the religious school violated the Persons with Disabilities Civil Rights Act. They didn't even talk about these issues that are before this court today, and I don't know if that's something where they agreed to have the court talk about that, or if the defendant overlooked it. It's an excellent question, Your Honor. I don't know if the parties could get together and do that. I hope I'm interpreting the
Well, I mean,
Your
what's
Honor's
wrong
question
with
right.
the proposition that the ecclesiastical exception is grounded very simply in the First Amendment, the religion clauses of the First Amendment of the Constitution, and they're defined, their breadth is defined as a function of what the Constitution has to say in its free exercise and establishment clauses.
One of those exceptions in the First Amendment that the Supreme Court has consistently recognized, though, is that statutory exception. And that goes back to that Reynolds case in 1879, which is the polygamy case, where the defense to the polygamy conviction, the criminal law, was that this is part of our church doctrine. The Supreme Court said, if you could, by dint of your religious belief, ignore the civil law that our government passes, then civil law that government passes means nothing. And the courts have consistently, up to Justice Scalia's opinion in the Oregon case, the Peyote case, where he said the same thing. I don't care that this is part of your deeply held religious beliefs. It's illegal. And we do the same thing. We don't let families who don't believe in giving medicine to their kids starve their kids or deprive them medicine or operations. We consistently say when you run afoul of a statute, you don't have First Amendment protection. And that kind of leads into that ministerial exception that the Hosanna Tabor case talked about in the Supreme Court. The Supreme Court was very careful there to narrowly craft that. The Supreme Court said, if you are somebody who is a minister, is a pastor, and you're an example, teaching the doctrine of the church, you don't have protection of Title VII. There's a case in Michigan that pretty much says the same thing. It predates Hosanna Tabor. It's a Assamani, I believe, a Court of Appeals case.
I have to ask you to bring your argument to an end. Your time is up.
Yes.
Do you want to complete your argument?
Yes. If the court is not waiving, I would like to reserve a couple of minutes.
You can't reserve. Your time is up, so I'm asking you to bring your argument to an end, if you would, please.
Oh, thank you, Your Honor.
Okay. Well, are there any further questions that anyone has? Okay, thank you.
May it please the Court, James Walsh, appearing on behalf of Notre Dame Prep and the Marist Fathers. I think the questions the Court has posed to my friend tell us what this case is all about. Catholic schools do more than teach secular academic subjects. As Justice Douglas wrote in the Lemon case many years ago, the advantages of sectarian education relate solely to religious or doctrinal matters. Hosanna Tabor told us that the government can't oversee, supervise, review a decision on who teaches religion. Well, the corollary to that is a court can't oversee or supervise who is taught religion. And there's no question that Catholic schools exist to convey and cultivate Catholic tradition, beliefs, morals. My friend said he didn't go to Catholic school, but I did. When I started Jesuit high school in New Orleans, they put everyone into a room, and they told us that the purpose of our education there was to transform every one of us into a man for others. It permeated our school. We got a good education, but Bettina can get a good education if all she wants is algebra, chemistry, biology. She wants to go to this school because it has a religious component. And Justice Bernstein asked, what does your client want? And I think it's a great question, because what relief can be granted here? She's already, I think, a junior in high school. What other relief can there be but
you're
money?
not arguing that this case is moot, are you?
Excuse me?
You're not arguing that this case is moot.
It may be based on what my opponent told this court, because if it's not injunctive relief, compelling the school to admit her, the only other relief could be money damages. Unless I'm missing something, but I think that's what the court can do. Now,
Well, are money damages available under the statute?
excuse me, Your
Are
Honor?
money damages available under the statute?
I think they are.
So, is the case moot?
I think it is. What relief can this court grant?
Money
You can't,
damages?
if you grant money damages, you've got the same penalty that Hosanna Tabor said you can't grant. Money damages is punishment for exercise of a right protected by the First Amendment.
No, that means you win on the merits. That doesn't mean
That's
it's
right, it's
moot.
not moot.
Yeah, they're not the same. But let me ask you, so from your briefing, it seems you agree with the plaintiff that the ecclesiastical abstention doctrine is not a question of subject matter jurisdiction. What do you think it is? Where does it fit in doctrinally?
I think based on Hosanna Tabor, it's an affirmative defense.
Okay.
Because the ministerial exception is still an intrusion into religion, just like the ecclesiastical abstention doctrine. But the Supreme Court there, and there was a conflict among the different circuits, said, we believe it's an affirmative defense.
And is it fair, I'm guessing, is it fair for me to assume that you think it's an affirmative defense, but it can still be, depending on how it's asserted in the pleadings, the case can be decided at the pleading stage if the only question is one that the defense governs?
If it's not decided at the pleading stage, then you have a court asking questions like, is this student qualified under your religious criteria? How can it go beyond the pleadings without intruding on an area we know is protected by the First Amendment?
Are there any decisions? Oh, go ahead, sorry. No,
I was just going to ask, couldn't the litigation proceed such that once there were questions of ecclesiastical doctrine, the court would defer to whatever the religious institution, here the Catholic Church, said was the matter of doctrine, and the court will accept that judgment and then apply that judgment to the non-ecclesiastical facts of the case?
But the judgment by the school is, this child, we don't want to teach our religion to.
And is that because there's some religious reason not to admit her to the school?
No.
Right, so that's where I get puzzled.
Well, I believe you have to follow the framework of Hosanna Tabor, where Justice Roberts wrote, you don't have to give a religious justification to fire your ministerial employee. Once even asking if you have a religious justification, the court oversteps the limits of the First Amendment. I think the same thing applies here.
So what you'd like to do is have us apply the doctrine from Hosanna Tabor and extend it from teachers of the religion, which was at issue there, to students.
Well, it's not, no.
I mean, that might not be a crazy, I'm just asking if that's what you're asking for.
No, what I'm suggesting is that the Hosanna Tabor holding is the flip side of the Lakin holding, that a religious school has an absolute right under the First Amendment to decide who it will admit or not admit.
So it sounds like what you're saying is the decision about who to admit is just falls squarely within the ecclesiastical abstention doctrine as an affirmative defense. Are there other decisions a parochial school could make that you think would be outside of that doctrine? Just to help me think about what, are there other decisions a parochial school could make that you would say would not fall under the ecclesiastical abstention? I'm just trying to tease out where the lines are.
I don't know. Certainly, the selection of curriculum. If you go back to the Lemon case, where the court found entanglement when Pennsylvania and Rhode Island funded secular subjects at school, I think the Supreme Court was quite clear that religion permeates the entire operation of a parochial school. And that's why it was an entanglement to fund teachers of modern language, of science, that it's almost impossible to find some aspect of the school, short of a bus service or lunchroom, that does not have a religious component to it.
Isn't that precisely, though, why Justice Taylor might have been right in his dissent in the DeLakin case in indicating that to confer such broad impact and implication upon the concept of the atmosphere or the environment of the school, in which almost everything is in fact covered, and in which you're having difficulty responding to my colleague Justice McCormick that there's much that isn't covered, you're basically having the exception consume the rule, aren't you? The ecclesiastical exception is basically encompassing almost everything involved in the governance and the administration and the curriculum of the school.
Well, certainly the government could require testing in secular subjects, could require standardized tests like the ACT, a lot of things that the government could do. But when the government says, you've got to teach religion to this student you don't want, that's crossing the line, clearly.
Counsel, I have a question. First off, good morning. How does the school handle accreditation?
How does the school?
Accreditation issues.
My hearing aid must not be working.
No, I apologize. No problem. How does the school handle issues of accreditation?
Issue of
Are you accredited
accreditation
by some outside body, I think is
Oh,
what he's
I think
asking.
yes. I think they are. There are, and I don't know that subject.
But I guess you understand.
I know Catholic schools are accredited and usually prized because of the quality of their education.
No, of course, but you understand kind of my question, though, right? There's still other issues that go into the governance of a school, and accreditation would be one of those. So what role does accreditation have in terms of the curriculum or implication of this doctrine?
Well, it certainly can require certain subjects be taught to be accredited. So much foreign language, so many years of math and whatnot. But it can't control the content of those courses. And as Lemon said, all of those courses can be used as vehicles to convey Catholic beliefs and doctrines.
And Counsel, I just want to understand the argument that you're making. I just want to make sure I grasp exactly what you're kind of saying. Is it, in fact, your argument that ultimately, in this case, is it the position of your client that they do not want this client to have the right to be a part of the Catholic education? I mean, is that really the crux of your argument, that this school does not want this child to have a Catholic education?
No, Notre Dame Prep does not want this child to be its student. It never made a judgment of whether Bettina Winkler would be a suitable student in another Catholic school.
But, okay, I just want to make sure I understand. So you're not saying, because I thought that what I heard you say was that this school has the right to determine that it does not want this child to receive a religious Catholic education at this institution?
It does, clearly, and that's the decision it made. It said, we do not want Bettina Winkler to be a student at our school, which has, as Justice Markman quoted, a significant religious component.
But is,
Now,
is that because of the religious component, or is it because of necessary accommodations that would be needed in order to allow for this child to succeed within this institution?
I don't think you can separate those two,
How's that?
because the pastor, principal, whoever makes the decision, can say, we will not be able to effectively convey our faith to this student and all the other students in her class if we make adjustments.
But you haven't made that point. I mean, that's a very different point than simply saying that we don't want Miss Winkler in our school. To say that we don't want Miss Winkler in our school because it will affect adversely the nature of our Catholic education generally throughout that institution, that's a different argument. You haven't made that.
Clearly, we have not made that in our brief. I was just responding to the question posed to me. But no, our argument below, our argument in the briefs has been we get to decide who can or can't be a student at our religious institution.
I'm sorry. I apologize, Chief.
No, I'm sorry. But unless there's a religious basis to that argument, as Justice Bernstein is indicating, the Persons with Disabilities Civil Rights Act tells you that no, in some cases, you don't have the right to make that decision. Isn't that right?
I disagree. And again, I go back to Hosanna Tabor. I think you can't even ask me, do I have a religious justification for selecting or not selecting a particular student. You couldn't ask me if I have a justification on who I'm going to allow in my church pew. I see nothing different.
How do you think that the Smith versus Oregon case would have resolved this issue? I mean, at a time that we're curtailing in some respects the breadth of the free exercise clause when it comes into competition with neutral government policies, generally applicable neutral government policies, you're essentially arguing for a broadening of the ecclesiastical exception.
Well, but then Hosanna Tabor applied the ADA, the parallel of the state statute under which this suit is brought, and Justice Roberts was clear. You can't ask the question without intruding into an area protected by the First Amendment.
So, counsel, it now sounds to me, I asked you previously if you thought that the way you would like this court to resolve this case is by applying Hosanna Tabor, which applied to selection and firing of ministers, teachers,
Yeah.
and you would just like us to extend that case by applying it to students. So from the instructional side of the classroom to the receipt of instruction side of the classroom, and you said no, but now it sounds to me like you're saying yes.
Well, if I misspoke before, because what I think I'm asking the court to do is to recognize, as the Supreme Court recognized in Lemon, that every component of a parochial school, Catholic education, is permeated by religion, and any government oversight or Lemon assistance to that school entangles the state in a religious institution. So what I'm saying is any inquiry by a court about why a student is or is not accepted in a Catholic school would cause entanglement by that court in religion.
Okay, well, your time is up, counsel.
Thank you very much for your attention.
Okay, thank you very much. The case is submitted. Thank you both.